Good afternoon, everyone. For those who don't know me, my name is Alexis Alvarez, and I'm the Director of Statewide Training at Florida Legal Services. Thanks for being with us today. I'm always happy when you come to learn with us. And today we have a really interesting topic covering, those dynamic changes that are happening in the 2023 legislative session. This particular webinar training will focus on housing and immigration and preemption. And we are extremely lucky to have two speakers from Florida Policy Institute. So we know they know their stuff. And before I turn it over to them, as always, I'm going to go over some housekeeping announcements. First and foremost, CLE credit for this is still pending, but don't worry, I will get you that CLE code once I receive it from the Florida Bar. You'll receive that CLE code from me in email. My email address, I'll drop it into the chat. So you can jot it down. You can follow up with me. You can say, hey, Alexis, where's the CLE code? I'm happy to answer any questions you have, and I will be getting that code to you as soon as I receive it from the Florida Bar. Second piece of housekeeping announcement is questions and answers. Our questions and answers. We want to hear from you. So don't be shy. We will have parts of the presentation where there will be space for questions and answers, but we also want you to drop them into the Q&A. While one of our presenters is speaking, the other presenter will be looking at the questions and vice versa. So we'll be able to get to those in live time. So don't be shy. Don't think you have to wait till the end. Please feel free to drop your questions into the Q&A. And as always, I encourage you to please get involved in the Q&A section that we have built into the presentation. Third piece of housekeeping announcements is this is being recorded. A copy of this recording will be sent to you within 24 hours of the event. So it'll come from Zoom. It'll be by noontime tomorrow. Again, if you don't receive it, you can always reach out to me directly, and I'll put my email address into the chat. Along with that announcement, our speakers have graciously offered to provide a copy of their PowerPoint in a PDF form for you all to be able to look back at the resources that you're getting here today. So you will be receiving a copy of the recording, a copy of the PowerPoint, and as soon as I receive the CLE approval, that will be coming your way. So I always want to get through the boring stuff as fast as possible. So I'm going to move on and say thank you to our speakers here today for being here to talk to us about housing, immigration, and preemption in Florida for our 2023 legislative session. I'm going to turn it over to them for introductions and to get started.
Hey everyone, my name is Cicely Hodges, and we also have Alexis. You have to pronounce your last name for me. I'm so sorry, Alexis.
Tsoukalas.
Alice, I apologize. Sorry about that. But I'm a policy analyst that focuses mostly on housing and community development. Alexis is a policy analyst that focuses a lot on mostly on immigration and labor. And we both work for Florida Policy Institute. So welcome to the Lunch and Learn. We'll be talking about some housing and immigration laws today. So FPI, we are a nonpartisan policy, we're a nonpartisan policy organization. We're committed to advancing state policies and budgets that improve the economic mobility and quality of life for all Floridians. We also analyze the state budget and revenue trends. We propose common sense policy options with the aim of encouraging broad public education, discussion, and informed action. All right, and we do this through our links. Today we will be talking about 3 housing laws, 1 immigration law, a not so fun preemption law that's pretty broad, and we'll have questions after each section. Please put the questions in the Q&A box because that makes it easier for us to keep track. All right, so we'll start off with key housing legislation. The first one we will talk about today is HB 133, which is the fees in lieu of security deposits. This allows landlords to offer tenants to pay a fee in lieu of a security deposit or to break up the tenant's security deposit into monthly fees. They have to offer both. And if they offer it to one tenant coming in, they have to offer it to all tenants coming in at that time. If they choose to stop offering it, they have to stop offering it for all of them. So the tenant, while in the fee agreement, can agree to revert back to a security deposit, but the fees that they pay, like starting in, will not go towards that security deposit. The security deposit is going to be based upon either the initial agreement that the tenant and landlord made, which is written, and you'll see it. And if there's no amount in there, then it's going to go to what would be a reasonable security deposit for a sufficiently similar unit, or a substantially similar unit at the time of the reversion, not at the time of entering into the lease. And again, if the tenant accepts, there must be a written agreement signed by both the tenant and either the landlord or an agent of the landlord. I have the elements of that if anyone has a question later on. As far as insurers go, so when a tenant moves out, the landlord has up to 30 days, like within 30 days, they must submit a notice to the tenant saying like, hey, this much rent, these many fees, these many damages, like beyond wear and tear, are going on, pay those. And then 15 days after that, they can submit a claim to the insurer. They have to have a lot more intricate itemized things on the documents to the insurer. I have those elements as well for questions later if you have them. And if the insurer has a subrogation right, it has to file against the tenant within a year of the end of the leasehold. All right. So the impact, there is, potential predatory behavior by landlords. There's no cap to the fees that are talked about in the law. So that's something to be careful, like be cognizant of. Drafting the contracts with language that includes reasonableness is a good idea, but also the better idea is just for the tenant to pay the security deposit in monthly installments. That way they're not having to like pay money down the line, like if they want to revert back into it, and they don't get stuck with that kind of like, maybe they get charged for all these like crazy fees. It is supposed to be stuff that's covered under the lease, but you never know what's going to come up or like what's going to be said is broken, that was broken when they moved in. So one of the big things is tell the tenants to document everything. Okay, so it should make people easier to move in. So that's like a good thing. Homeless families have like been rising really crazy over the past few years. In fact, in the Suncoast, homeless families are up 200%. A lot of that is the incredibly high cost of moving into places. So this will make it easier for people to move in. They just have to be cautious when looking at the drafting language and stuff like that. And then tenant unions will also help curb this predation, because then the tenants have each other around. They can they'll have substantially similar units, even though it's like a different market, but maybe someone else is coming in who decided to pay the lease. It just kind of helps them get an idea of like what is the right amount that they should be charged if they revert to a security deposit. And it also ensures that the landlords are following the part of the statute that says if you offer it to one, you offer it to all. The second one is residential tenancies. This is a huge preemption bill that took all of Chapter 83, which is the landlord tenant law, and put it up to the state. So now local jurisdictions cannot write any like ordinances on matters that include but are not limited to the screening process is used by the landlords, security deposits, rental agreement applications and fees, terms and conditions of rental agreements, rights and responsibilities of the landlord or tenant, disclosures concerning the premises, dwelling unit, rent agreement, or the rights and responsibilities of the landlord or tenant, fees charged by the landlord, or notice requirements. Though, in order to appease some of the localities that had extended the notice requirement from 15 days to 30 days for month to months, this bill makes the minimum 30 days. So now there's no longer a 15-day minimum on notice of termination for month to month. It's now 30 days for everyone. The downside is that applies to both the landlord and the tenant. If they're going to end the tenancy early, they have to give, or if they're going to end the tenancy, they have to give 30 days notice. There's no exceptions. So I'm actually going to start with the bottom rung because that kind of goes in. There's no exception. So that means that if you are a victim of domestic violence or your client is victim of domestic violence, they still have to follow the notice period. And so they can be penalized by not following the notice period. Yeah, and then it also just takes away power from localities. Okay, so thank you. All right.
Sorry,
So
my dog hit me.
no, it's okay. I thought I was going too slow. All right. So it also it undermines local power and affordable housing and housing equity because it means that like local governments have no say over Chapter 83, anything to do with tenants' rights. If you're in housing law, you know how few rights tenants have already. So that makes it a bit more frustrating, especially because localities tend to know a little bit more about what's going on in their particular, like backyard better than the state. Also, it's not really uniform amongst counties, but they're trying to make it but they make it uniform this way. It also weakens already weak tenant rights. Because all of the extensions that localities had provided to Chapter 83 were tenant friendly. They were longer notice periods, more transparency on tenants' rights, agency assistance that would help tenants procure lawyers or help them in, like before trial, like before anything even happens, trying to avoid an eviction at all. All right.
I'll just say no, we're ahead on time, so take your time.
Okay, sorry. All right. The last one, it was a really big one, but it's only gonna really matter to those of you that might do housing development or any kind of real estate development if people are considering doing getting Live Local funding. So it creates the Live Local program. This is a whole bunch of money that's being put towards the SALE program, which is the State Apartment Incentive Loan Program. This is given to private companies, not local governments. That's shipped, so nothing in Live Local is going to go to the local governments. There's like a regional project thing that might be argued that you could do, but that one's going to take like people coming together to try and figure out what the project is, and there's limited funds and there's a lot of restrictions on it. It also extends the Hometown Heroes homeownership program so that it's all it's actually past the qualifying public employees. Now it is people within within the workforce income range. So that's if you purchase a home, you want to get a mortgage, it's your first home and you fit within the income limits, then you can get a 0% interest loan from the Florida government. It's going to be a minimum of $10,000 to up to 5% of the initial expense, but that caps off at $35,000. And then it also
I'll point out too that it used to cap at 25,000, so they did increase the cap. And when we say Hometown Heroes, it's generally, well, it was before this, frontline responders. So a lot of like hospital staff, EMTs, firemen, things like that.
Yeah. And then it creates a large tax credit screen, about $100 million in tax credits for corporations. That if they donate to the Live Local program, they can get that amount back in a tax credit for, other tax purposes. And it also preempts the rights of local governments to create or enforce rent controls. Part of that is believed to be kind of in response to the referendum that happened in Orange County where they did a rent control. All right. Okay, so it undermines local power in affordable housing and housing equity spaces because of the preemption of the local governments to create and enforce rent controls. It increases the privatization of projects rather than funding local governments because none of it goes to SHIP. It goes all to SALE, which is only private loans. In multiple sections, it allocates project money specifically to private developers, and it encourages local governments to consider private market solutions first when funding projects. this can be somewhat of an issue because private builders and developers and stuff, they are usually only held to maybe a 20-year affordability period, whereas a local government, oftentimes their affordability periods are 99 years. So yes, all this housing will be built, but in 20 years, it can go back up to market rates rather than in 99 years when the state is halfway underwater. And then there's also a large reduction in state revenue just in general, because it's $100 million a year in tax credits. So that means that we're taking that out of like the general revenue. It's going to housing, but it will be taken away from the other services that it would have originally been funding. And again, it's going to sale. So with sale, 20% of the units, so 50 units have to be at 50% area median income or less. And then the remaining have to be what's considered moderate or workforce income. That's 81 to 120% area median income or AMI. If the development gets low-income housing tax credits called LIHTC in acronym, they can do 40% of the units at 60% AMI flat, and then the rest have to be that workforce moderate income range. So the majority of the housing that's going to be built is going to be built for moderate income people. Are there any housing questions? Let's look in the Q&A.
And so at this time, if anybody does want to present any questions that they might have off of mute, because I know the virtual world is really hard to connect in, what you can do is you can raise your hand. And if I see you raise your hand, I'll be able to take you off mute to pose your question, and then I'll remute you so that our speakers can answer. So feel free, raise your hand. Raise your hands.
Alexis, quick question. I just want to ask, because I think I shared the file and not my full screen, but like if I click up here on like Q&A, do you see that pop up on your screen? Nope. Or only me? Okay, only good. So I can still answer later. Okay, that's just what I wanted to check.
Sure can. Nope, just so we can see your mouse a little bit here and there, but no.
Yeah, I'm gonna try to stop going like this.
I've done that many times in my webinars, so don't you worry.
I will also say that we're throwing a lot of information at you. I mean, I know a lot of y'all are lawyers, so you're used to it, but sometimes it takes time to process. So, we'll have our contact information at the end too, if you think of things. But yeah, I'd say if nothing now, we can.
Yeah, nothing now. And if we have time at the end, and if you have time at the end, we can also do the same thing, open it up for people to come off mute if they've, thought of any questions at that point. So, I say carry on and folks, put your questions in the Q&A or we'll raise hands later.
All righty. So now I'm only going to be talking about one bill because this bill has so many provisions and it's really a bunch of different policy areas rolled into one. There's a lot to talk about. Now, this is on the legislation that became law, known as SB 1718, very controversial bill. I'll just say too that FPI has been immersed in this since the governor first announced the proposal that became this legislation. And we watched it evolve in all of its iterations and been very intimately involved with partners on the back end and informing legislators and things like that. And we continue to monitor its impact with partners. So a lot of what my slides are going to reflect are the key. I'm not going to go over all of the provisions, of course, but the key provisions that got the most attention during session because they have the biggest potential impact. Also because we're still seeing a lot of misinformation out there from impacted groups, from immigrants, from providers, from business owners, and we're trying to make sure we clear some of that up. So these are just kind of the 5 or so policy areas that I'll cover. I'll say we were able to improve some of the bill, specifically the human smuggling provision was much, much, much worse. And some business groups did, I think, lighten some of the penalties on the E-Verify provision. But other than that, everything pretty much has been the same from the introduction of the bill to what finally passed. And most of those provisions are now in effect as of July 1st. And there's a couple that will take effect a little bit later. And some of those I will discuss. But just generally to know, this really is one of the most sweeping anti-immigrant laws we've seen. I've only been doing this, for 4.5 years or so in this particular job, but talking to advocates who have been at the Capitol for years agree. So the first one I want to talk about is the health data collection provision. So essentially, this says that all hospitals that accept Medicaid in Florida, which is most hospitals, I think there's about 323 of them, they have to start asking ER visitors and admitted hospital patients their immigration status. You might hear my cat meowing in the background. I apologize. He hears me talk and then he thinks it's his turn to talk. So actually the only minor change that happened here is originally the bill was for all admitted patients. And the hospital group, for whatever reason, narrowed it to ER visitors. I think perhaps that was less administrative burden on them. Regardless, what will happen is there's a form and the bill actually outlines the questions that should be on the form, not the specific language, but the responses. And it'll say, are you, a US citizen or legally authorized to be in the country? Are you not? Or do you decline to answer? So decline to answer will be an option, or is an option. And then none of this is going to be personally reported to the state. It's going to be collected in aggregate and the categories sent to the state to basically try to say, well, here's how much we pay for US citizens. Here's how much we pay for non-US citizens or those not authorized to be in the country. And here's how many people said decline to answer. And I'll come back to that decline to answer in a moment. But it's important to point out this is only hospitals that accept Medicaid in Florida, no other medical providers. We've heard some stories about clinics thinking this applies to them and turning away care. That should not be happening. Also, it's in the language of the bill that the form also has to tell people, just because we're asking you this question, we still have to provide you care. It cannot impact your care, and nor will it. And that we're not reporting any personally identifiable information to the state. So that's great that that language is in there. But unfortunately, we've seen that there would still be most likely a chilling effect with this, because you can tell people that all day, but if you are a marginalized group who is already fearful and distrustful of authority figures, especially if you have an undocumented status, or maybe your status is in flux, which it often can be in the case of undocumented folks, that's not going to be a comfort to you. And we're already seeing and hearing concerns about people going and avoiding care, or even talking about leaving the state. So obviously that's terrible for individuals, but it's not good for our public health either, because then these smaller issues where they could have gone to the ER, or they could have, maybe they needed to be admitted, now they become huge issues and costing all of us more money and lives. So there's also some confusion, as I mentioned, about some providers as to whether the mandate applies to them. And we want to make sure people know it's only hospitals that accept Medicaid. And I wanted to come back to the decline to answer, because one of our partners, the Florida Immigrant Coalition, they are organizing a campaign basically to encourage everyone, regardless of, like me, I'm not an immigrant, to, even if I were asked that question, to say decline to answer, because it is an option, and it shows solidarity with the immigrant community and hopefully kind of quell some of the fears. So that's the health provision. I'm going to briefly talk about the out-of-state driver's license provision, which is interesting in how its impact has actually ended up manifesting. I'll say too, FPI has been part of the group of organizations pushing to actually extend driver's licenses to all, meaning that if you are undocumented, you could still get a driver's license. It would only be used for that. You can't vote with it. You can't fly with it. It's just a driver's license. But instead, the state retaliated and said, no, not only are we not going to pass that, but now all those other states who have driver's licenses that are inclusive, we're going to make those invalid in our state. So that was the aim of the legislation. Anyone who comes from a state, then there's 19 other states plus DC and Puerto Rico who have inclusive driver's licenses. They'll not be able to use it in Florida. If they get pulled over, they're going to have a citation issued. And you can imagine if that person is undocumented, now that's an additional way for them to get detained and potentially deported and reported to ICE. Because law enforcement can already do that, but now they have, an extra reason potentially to do that. But it's important to know that doesn't mean that people in these other states should stop getting them or that other states aren't allowed to start these programs. This just means if you come here in Florida, we're not going to recognize it. I'll say now here's where it gets interesting, because in theory, the bill was going to ban all of these states that have them. But because of the way they wrote the bill, it's much more nuanced as to who is actually going to be impacted. And so it's if there is a distinguishing marking present, like, big red flashing light, this is clearly a proxy ID for undocumented folks, or if the license is the type that only undocumented immigrants can get. So a lot of states were very smart when they passed these and knew that this could be used as a proxy identification to call out undocumented immigrants. And so they specifically tried to minimize both of those situations. And that's why there's actually only 3 states now on the list where those licenses are invalid. Interestingly, it was 5 July 1st when it first went into effect, and they keep removing other states. Hawaii might be the next one. So in a dream world, we're going to see 0 on there, and then this provision is moot and means nothing, but we'll see. But if it is fully enforced, the concern is we have a lot of tourists. Yes, we get international tourists to Florida, but in reality, most of our visitors are domestic, and most of them come here by car. They're not flying. So most of them need a license or an ID. So this could impact many people, not just undocumented immigrants themselves, but those, in mixed status families, children who might be citizens, but their parents are undocumented, spouses, etc. And I already mentioned here the concern about this sort of traffic stop to deportation pipeline. There's definitely concerns that this will, be used to racially profile and assume that someone is an immigrant or they are an undocumented immigrant. So let's pull them over and, check their license and use that as a way to detain or deport them when they're just going about their day. Somewhat relatedly, so community ID also has a preemption provision in SB 1718. So let me explain briefly what a community ID is. Sometimes similar program called a municipal ID program. Essentially, it's an alternative form of identification for those who can't obtain a state ID or driver's license. And, Florida being a state that doesn't have ID options or driver's license options for undocumented immigrants, this has been very appealing to local governments. As with most of these pro-immigrant policies, it started in South Florida and Miami-Dade, but it started to spread to other places. So this is in direct response to that. Like Cicely said, the preemption of local rent control, even if you read the state's analysis of the bill, they specifically mention Orange County's rent control provision. So it's at least been considered in the legislation, and same with the community IDs. So some reasons why these are needed, so you have a lot of domestic workers in Florida who are immigrants, and if they don't have specific identification, let's say they're going into a gated community where they clean homes or they provide home care services, they need ID to show security, and maybe they don't want to see their passport or something like that. Sometimes you need them just to pick up your kids from school and to daycare, to check out library books. And much like with the driver's license movement in other states, these IDs can benefit people beyond just undocumented immigrants. So other people who have opted for these community IDs include domestic violence survivors. Maybe they don't have the papers that they should have because of the control that they were under to file and get a proper state ID or a driver's license. So they have a community ID card, or they don't want to be in this system because they don't want their former spouse or significant other to find them. And then those who experiencing homelessness have a real difficulty in getting documents they need to prove identification for things like this. So I'll say, essentially, law is saying that now cities and counties are not allowed to fund community ID programs. So if you have a community ID program in Miami-Dade, there's private funding involved, but a lot of them are funded with public dollars because it started with the passage of an ordinance or something like that. So it's important to know this isn't invalidating community ID programs. It's not saying if you have one, you can't keep it or you can't pass future ordinances. It's only saying local governments are not allowed to pay for them. So that means any of these programs that rely on government funding are going to have to rely, on private foundations and individual donations. So it's still unfortunate, but at least it's not a full preemption. So I guess silver lining on that one. I do see there's a question in the Q&A, but I'm going to keep going on my end. And then if it's something for Cicely, she can answer, or we'll handle that at the end. So these last two provisions are, I'm going to just pull up my timer, make sure, okay, I'm good. These last two provisions are pretty meaty. There's been a lot of media coverage and confusion around them. So I saved them for the end because I imagine people will have questions on them. So the first group is on hiring and e-verify mandates. So there's actually two sections on employing undocumented people in Florida in SB 1718. So the first section amends Florida statutes 448.09 on banning the hiring of undocumented workers. Now this is already illegal at the state and federal level, of course. The difference is starting next year, July 1st of 2024, SB 1718 is adding much harsher penalties if either the employer or a worker doesn't comply with this. So some of those include, if you're a business that receives some economic development incentives, these are things that are used if you're not familiar, like come bring your business here, bring so many employees, and we'll give you a tax credit. We can talk about issues with those tax credits on another webinar, but one of the penalties would be you have to repay those incentives back to the state. You'd be put on a 1-year probation, and you'd have to submit quarterly reports to the Department of Economic Opportunity until you're in compliance. More severe option 2 is you can have your business license or licenses suspended if you have a second violation within 2 years. And then for how long that license is suspended, it's tiered based on how many undocumented workers you hired. I didn't include that information here, but the links that we'll share with you will have that detail if you're interested. And then finally, pivoting to the worker side, if any worker to get employed uses false documentation to get hired, they are now subject to a 3rd-degree felony, which is up to a $5,000 fine or 5 years in prison. So the second section, I'm going to go through both sections, and then I'll talk a little bit about the impact specifically of the e-verify side. So the second section is also called the e-verify mandate. This is the one that got a lot of attention during session. All of it is effective now, except the penalties, which I highlighted here, July 1st, 2024. So this is saying all private employers, nonprofits, companies, anyone private who has 25 or more workers will have to use the federal e-verify system to ensure that their new workers are legally authorized to work in the US. The current status is that only public employers have to do this. SB 1718 expanded it and said, sorry, not the current status. The status before SB 1718 passed was that only public employers had to do it. Now private employers have to as well. And previously they could use either the e-verify or the federal I-9 form. Both were acceptable. Now it's only allowed to be e-verified. So if a business also finds out that any of their employees are undocumented, they cannot keep them employed, so they'd have to let them go. I've already heard some news stories of this happening. And then it creates other penalties if they're non-compliant. For their first and second offense, they get off pretty light. It's a 30-day warning, and they have to get in compliance. But if it's their third offense within 2 years, then the fines get specifically very harsh, and businesses will start to be fined $1,000 a day, and all their licenses being suspended until they are back into compliance. It's important to point out that this does not require employers to run e-verify and pass hires. So if you already have people on staff, as of July 1st of this year, you needed to start screening people. Don't need to go back and rerun past hires. I've heard some other lawyers speak on this, and they actually specifically, I'm not a lawyer, but I've heard lawyers speak on this who say specifically they advise against that, because that could actually slow things down, and then you're running this on people who don't need to be. It also doesn't impact staffing companies. So like if you're a subcontractor or you lease employees to a certain group, or you have a temp agency, if that client company of yours already agrees in writing and has said, well, we use E-Verify, then that staffing company doesn't also need to use it. It doesn't need to be done twice. It's just as long as there's someone covering it. And finally, the language in this specific section only, the E-Verify provision says is only impacting permanent employees. So not non-permanent positions. But now that other section on employing undocumented workers does not have that language. So it could, in theory, apply to all types of workers, seasonal, migrant, and so forth. So just talk a little bit about the analysis that FBI has done on the potential impacts of this. And you'll see pink underlined, those are hyperlinks when you'll see them from the PDF. So my coworker and I, Dr. Esteban Santis, did an analysis of this during session. And one aspect, the worker punishment. A concern there is, in theory, the state is saying, well, we could get this $5,000 fine, and if people pay this fine in lieu of imprisonment, if we catch them using false documentation, and then that'll bring in revenue to the state. The issue is that we know most people are probably not going to be able to afford that. That's almost 10% of Floridians' median household income. And then we know undocumented immigrants in particular earn even less than most Floridians and most US-born workers and naturalized citizens. So the state's not likely to see a big revenue boost. And on the other hand, they're likely to see revenue loss and higher expenses because now we'll have to pay to imprison these people. And in our brief, we do get specific with our estimates of the cost of incarceration if you're curious about that. Obviously, these are all estimates and predictions. How data is, you have to work with imperfect data and do the best that you can. But it gives us an idea. So some of the other highlights from our analysis is looking at labor statistics data and seeing, kind of where immigrant workers, specifically undocumented workers, tend to be employed in Florida. Coincidentally, are also some of our top industries: construction, food services, entertainment, retail, of course, agriculture. So if all of those employees that were undocumented were forced out of the workforce, because if you find out you have an undocumented person on staff, you have to fire them, or you're not screening those you have to use E-Verify to screen those new employees, we could see Florida lose up to 10% of employees in these top industries, or close to 400,000 workers. That's a significant amount. Again, we're already hearing personal stories and stories from employers about people not showing up to jobs or straight up leaving the job site. And that was even before July 1st when this went into effect. So it is a concern that this could be very damaging to our economy and to people's livelihoods, of course. And when you consider the wages that people contribute, that's one way to look at gross domestic product. And so 10% of those workers and the wages they contribute in just a single year is $12.6 billion. So imagine if that's compounded annually, even just 1 year, that could be devastating to our economy. And the third point I want to make on the fiscal side is that many people don't realize that not all undocumented people, but many do actually pay taxes. They pay state and local tax revenue. Part of that is because some of them feel that if I do this, it'll make it easier for me to become a citizen later or to adjust to a legal status. So we know from our partners who are tax experts who have analyzed this that at least $920 million each year comes from state and local tax revenue from undocumented folks. So if you are taking away some of those people's income and you're kicking them out of the workforce, well, now you're going to lose other state revenue. And saying state revenue, it's kind of an obscure, opaque thing, but it matters because it feeds into all of the public services and programs that all of us benefit from: our public schools, our criminal justice system, our healthcare. So it's not just going to impact immigrants, but it could potentially impact all Floridians. And the last thing I'll say is, in theory, E-Verify sounds great. Let's screen everybody and make sure that they're legally authorized to work. We're not breaking any laws. The issue is there's a steep administrative burden, especially for smaller businesses. And there's been studies by the own government reports error rates with E-Verify, the federal government. Libertarian groups like Cato Institute have also come out against it because it's not a perfect, it's beyond a perfect system. I mean, there's no system that's perfect, but there are consistent flaws and errors in where it'll actually say this person's not authorized to work, but they're maybe even a US citizen, or they at least have a green card or another authorized work status, and it's rejecting them. And yes, that can be corrected, but it costs time, there's more paperwork, and in the meantime, you have turnover, and it can just be very costly for businesses and for people trying to be employed. And so we estimated, based on the most recent error rate, that as many as 11,000 Floridians who actually are authorized to work could receive a false rejection just in a single year. And finally, we know that the Department of Economic Opportunity is not well equipped to enforce this. Florida does not have a Department of Labor anymore. We haven't since the 90s. And DEO has tried to take on some of the roles of what a Department of Labor would do, but it doesn't have the infrastructure and it doesn't have the funding. So again, they would have to put more money in to make this enforceable while they're losing money as a result. So I'm looking at my time here, and this is the last one. So I'm gonna go a little quicker through this one. So these are the human smuggling and the unauthorized alien transport program. I put alien in quotes because yes, that's a legal term, but it's not a term that we like to use to describe people, but that is the name of the program. Human smuggling provision, you might not be able to see this now because of how small it is, but you'll get this link. So it was becoming so complicated, and it was even much more complicated than this during session as to who this human smuggling provision would originally apply to. So we at FPI created a decision tree to make it easier for people to understand whether it impacted them and what the potential charges would be. So essentially, it boils down to you are not allowed to transport anyone into the state if you knowingly or you should have known that they were undocumented. If you do, and we find out, there are charges. And so this shows if it's your first offense, then, and you didn't transport 5 or more people at one time, and you didn't transport a child who was undocumented, then it's a 3rd-degree felony. And all the other circumstances bump it up to a 2nd-degree felony. So if you've been convicted once before, or if you haven't, but you had a group of undocumented people in your car. So let's say you're traveling with a family, or you're coming back from a soccer game out of state and some people are undocumented. Okay, that could apply to you. Or even if just one child is undocumented among those who you brought into the state. The idea behind this is let's crack down on professional human smugglers. So it's, again, nice in theory, but because of how broad everything was, and because a lot of the amendments were not considered that would have narrowed the scope of this bill, it's almost impossible to determine a stopping point as to who could be impacted. Of course, depending on how severely or broadly it is enforced. And I want to say the original bill was much, much worse. It originally made it a felony to transport anyone into and within the state. So you can imagine anyone who lived with an undocumented person, was married to one, even if you run a church and you run like you bring a group of people for a church event, or maybe you have a soup kitchen or something and you serve, a community that has a lot of undocumented people. If you knew they were undocumented, then you would be subject to these felonies. So this got tremendous pushback from the faith community and from all sorts of different advocates. And luckily they did remove that aspect. So that's at least a plus. Also, it does not ban housing or living with undocumented immigrants. The original bill did have additional language that said if you shield, harbor, or conceal an undocumented immigrant, now you're subject to all these felonies. And the last thing I'll talk about there is the UAT provision. So the Unauthorized Alien Transport Program, it started as a one-off. Well, we thought it would be a one-off last fall, a project from the governor to basically give transportation providers funds to send undocumented immigrants out of the state. Many of you probably heard about this when it made national news when our governor sent groups of Venezuelan immigrants to Martha's Vineyard. I think recently it's happened again, sending people to California. So that started as this program, 12 million in funds that were originally those funds are from interest that the state received when everyone got federal COVID-19 recovery money. So in theory, yes, they were allowed to use that interest, but was it ethical? Was that really what it was meant for? Those are the questions that came up. So besides the outrage statewide and national that came out against that, the legislature pushed forward and decided in a special session in February to make this program permanent and call it the Unauthorized Alien Transport Program. And instead of having the Department of Transportation run it, now it's in the Division of Emergency Management. And finally, during session, they said, okay, now that's a permanent program. Let's allocate more funding for it. So this year, there is an additional $12 million in funding for that program. So you can see these combined is encouraging people to not bring undocumented immigrants into the state and incentivizing people to kick them out of the state. That's why it groups them together. I'm not going to go through all this. One thing, because I touched on some of this, I'll say that I mentioned the interest part, and again, the fact that this funding comes from general revenue for the Unauthorized Alien Transport Program. So 12 million might not sound like a lot, but we analyzed the budget line item by line item. That could get us so many more things. We could serve more older folks waiting for care. We could serve people with disabilities. We could expand childcare vouchers. There's so many better things that money could have been spent on. And this is just what I mentioned here on the personal aspect, is that there are so many mixed status marriages in Florida. There's spouses who are traveling. Let's say you just go on a vacation and then you decide to come back with your spouse who may be undocumented. Now, if you get stopped, you could be subject to a felony because, of course, you know your spouse is undocumented. Also, seasonal migrant farm workers often travel in groups and caravans, often with their families, because it's more economical to do so. And we know a significant number of ag workers in Florida are undocumented. Other than that, I'll say I gave you a lot of information, and I see some things coming up in the Q&A. So before we go to the last part, which is just a brief rundown of the preemption provision, I want to just see if there's any immigration questions.
So what I can say, I can present what came into the Q&A. I received some clarification on that question. The question that came into the Q&A was in regard to the time that we were talking about, someone getting a driver's license. And the person said that it's just a thought, if one state allows someone to get a driver's license, doesn't the Privileges and Immunities Clause mean that that license is valid interstate? I thought that was one of the arguments that tipped the same-sex marriage. If one state recognizes it, another can't unrecognize it. This question is probably more of a philosophical brainstorming question, but wanted to pose it.
Yeah, I'll say that specific one you mentioned, I haven't heard, but we worked closely with Southern Poverty Law Center during session on this. And one potential counter that they mentioned was the full, I think it's called like the full faith and credit clause of the Constitution. And they're thinking similarly that that would violate it, because yeah, you can't just say that you invalidate a state's license for this reason. So I know that Southern Poverty Law Center started with a lawsuit on the human smuggling provision in particular, but they are planning, I believe, suits on some of the other provisions, and it could include this one. But also it's interesting to see as states come up and push back with Florida's DMV. We're seeing the number of states impacted drop off. So maybe that will take care of itself. But yeah, that's a great question. I do think there could be some federal legal avenues there to explore if needed.
And then the only other thing that came into the chat, it's also, again, a thought bubble. It says, hi, thank you for the presentation. From what we've researched, it's not really undocumented people. It's people who entered the United States in violation of the law and have not been inspected by the federal government since his or her unlawful entry. In other words, it seems there's a clear distinction between people who entered without inspection and people who did. For example, people who entered in with a tourist visa and overstayed, in theory, would not be included in this law regarding the smuggling part of the law.
Right. So we got into all that nitty gritty during session, and I'll encourage you to look at, I'll make sure I send Alexis some of the information, but on our decision tree, we talked to Southern Poverty Law Center about this to make sure we got it right too. We have sort of a footnote about this, about how we say undocumented because it's kind of an easier umbrella term, but really it's very difficult to narrow down who they're specifically referring to because they don't adhere to the framework that's in the INA, you know, the Immigration and Naturalization Act, the state lawmakers. And so the language is still, they also don't define what they mean by inspected, and they don't align it with federal definitions. So in theory, it could also apply to DACA recipients, those with temporary protected status, Violence Against Women Act status. That's the thing. We don't know how broadly they're going to enforce it. So it's very difficult, even for legal immigration experts that we've spoken to say it will or will not. I mean, ultimately, we're saying to people in the community, if you're unsure if it applies to you, consult a licensed skilled immigration attorney. But I think a lot of that is going to come down to enforcement. So yeah, these are all great questions and things that came up a lot during session, but I'll make sure you have the link to that nuance as well.
That would be great, Alexis. And one other question came into the chat, the Q&A, excuse me. Should we address it now or did you want to move on?
No, you can go ahead.
Question was, will SB 264, the bill banning Chinese nationals from buying land in Florida, affect how attorneys navigate related fair housing cases?
So that one, I'll say FPI wasn't involved in on that. So I don't have any insight on that, unfortunately.
All right, so those are all the questions. We got through them.
Okay, well, we just have one more little preemption issue that Cicely will talk about because it really could just impact almost every policy area, and we want to cover that, and then we'll wrap up. Let me get to that.
I do want to quickly state something that I realized I forgot. With Live Local, nonprofits offering certain kinds of affordable housing can have the property taxes, can have like property tax exemption, and local governments have the right to extend that exemption to private companies that offer the same kind of affordable housing. I just wanted to bring that up. So we might see some property taxes going down a lot, or at least the revenue generated. All right. So one big, the biggest notable preemption law is local ordinances, SB 170. It has been called by local government advocates the Death Star preemption bill. It was defeated last year, but this year it passed. So it amends 57112 to allow, which is usually like if you're suing because things are unconstitutional, that's what it's adding on. So now it allows people and businesses to sue local governments, of course, civil suit, for amendments deemed arbitrary and unreasonable. It does not define those terms, so we'll have to see how the jurisprudence goes.
Sorry, that's a typo. It should say amendment or ordinance because it could be an amendment to an ordinance. Apologies. I'll fix that before I send you all the slides.
Yeah. Sorry for an ordinance that is arbitrary or unreasonable. My brain was not thinking. So it also, for the plaintiff that brings the arbitrary and unreasonable case, they can be awarded attorney's fees, costs, and damages. None of that goes into like the attorney's fees that were accrued in determining how much these will be, but everything else up to $50,000 will be like fee shifted to the local government to pay. But if the local government prevails, there's no attorney's fees shifting or anything like that. It requires local governments to conduct a business impact assessment before adopting new ordinances. And so that's like seeing what the cost would be on the individual businesses, the reasoning for the law, just a lot of like what the actual impact would be, a good faith estimate on the amount of businesses that'll be impacted, and so on with every ordinance. Well, not every ordinance, not the ones to do with like extending the county like boundaries or anything like that, not to do with like firefighting. We'll actually talk about that in a second one. Okay. Oh, does it have it?
It's on the next slide, but yeah.
Oh, it's on the next one. All right. And then it does force local governments to suspend the ordinance in question in certain cases. So they can basically get kind of like a preliminary injunction before, like, they have to stop with the ordinance. Okay.
Until the case is resolved. And you can imagine if it's a large corporation or something and they have a lot of money, they could keep that going in perpetuity.
And on top of that, if they do appeal, then I think like the 45 days up to like the decision, depending on the ordinance, the county might have to stop, like go back into basically an injunction, even if they won the first case. So it does impact all any local ordinance or amendment except for fire and building code, zoning and development, and some fiscal, like budget related stuff, or the budget related stuff. It disempowers local governments. Suits cost money. The governments can't recover, so slap suits, not super fun. Smaller local governments will suffer disproportionately because they have less funding to deal with this. And it's going to scare localities away from governance tailored to their communities. So they're going to consider the businesses, but not so much the human beings that they're supposed to be representing. It caters to businesses. There's no like impact statement on like the community or the residents. It's only the impact on businesses. And large corporations can sue over issues they do not agree with. So arbitrary and unreasonable, it's super vague. They do not define it. We're just going to have to see how different judges decide. And one of the things to consider is, although judges are neutral and detached magistrates, in Florida, they're elected, which takes money. So that's something to consider when we're thinking about how these judges are going to rule on these cases. And business interests have a history of suing over pro-worker, affordable housing, and paid leave policies because they don't want people who are low income in their area because they see it as like reducing the value of their services or maybe their clientele. A lot of times they don't like the pro-worker stuff because then they have to pay more. So anything that the government does to try and kind of make these things a little bit better, there's a lot of times they're probably going to then get an initial like injunction. On the bright side, the courts do have to give priority to these cases, but like it's every ordinance. So how much are the courts going to be just like flooded with these? Any questions about anything?
So I think that we covered all of the questions that came in the interim breaks that we had. So, while folks are, getting any last minute questions into the chat or Q&A, I will quickly drop my email into the chat like I promised for anyone who needs. And I will remind folks who came in a little late that the CLE code is still pending, but I will be able to get that CLE code to you all via email as soon as I receive it from the Florida Bar. And I'm also going to drop in here a little message just about the recording and the PowerPoint. I see, someone asked if we're receiving the PowerPoint and we already answered, but just to say, you will receive a copy of this recording, a copy of the PowerPoint that'll come in an email from Zoom within 24 hours of this event, but you can always email me directly if you need it or need anything. I also put in here, so Alexis, the blog that I put in here was the blog on SB 1718. That is from you. I put that in there for anyone that might be interested in it. I don't know if you want to say anything about that or if you want any other like final last minute things. Only things coming in through the chat are lots of thank yous.
Oh, thank you. Yeah, there's several. We ended up putting several different pieces out. That's why I was asking which one was it, because we have a brief and then we have, which is like the fiscal analysis, some of what I talked about. And we have a overall bill summary where it just kind of explains these provisions. And then we also had that decision tree specifically for the human smuggling. So I'll make sure that you have all of that, because especially on the human smuggling, that gets into the nuance about who does this really apply to, who's undocumented, who's unlawful, who's entered without inspection and so forth.
Perfect. The one that I dropped in is the 5 things Floridians should know. So.
Oh yeah, that's the bill summary. Yep. Okay.
Awesome. Awesome. Well, again, through the chat, just lots of thank yous. And I also want to say thank you so much. I reached out, and I said, hey, is this something that we can put together, for our legal aid community to get abreast of all the stuff that's going on? And both of you really just jumped in and without any help from me, made an incredible presentation for our folks. So I also, on behalf of the legal aid community, say thank you very much for what you do. As sort of a hand in hand with the work that we're trying to do as well in one aspect, and you in the other. And it takes a village, policy, lawyers, everyone together to really try to develop change and to really try to serve the populations that deserve, the most. So with that being said, any last minute words before we sign off today?
I just wanted to thank all of y'all for what you do. We need the impact litigation and people need advocates. So thank you.
Awesome.
Thank you very much. And we appreciate you having us.
All right. Well, please, anytime you want to come back, I will be happy to host you again. And you might even find me knocking on your door begging for more. But
Sounds good.
so until then, everybody have a wonderful rest of your day. Thank you for learning with us. And thank you both for teaching us. Have a good one. We'll see you at the next training.
Bye-bye.
Bye.
Bye.